Good afternoon. My name is Mary Meg McCarthy, and I'm the Executive Director of the National Immigrant Justice Center. And I want to welcome you to our program entitled What It Will Take to Save Our Asylum System. People seeking asylum in the United States come in search of safety. They're fleeing persecution, violence, and sometimes death. They're women, men, and children, families who are not able to live safely in their home country. And what do they encounter at the U.S. border? They face complex U.S. immigration laws and policies and a very restrictive environment that bars many from seeking asylum. As many of you know, asylum is a legal right. In this country, we recognize that people have a right to enter the country to seek asylum. However, the restrictions at our border currently prohibit that. And the restrictions at our borders, in the courts, and in our nation's rules have become far more challenging for those individuals seeking protection. This is a human right. These are about individuals. And now more than ever, we as a country should be welcoming those who are fleeing danger. However, the reality is asylum seekers are facing hurdles, erected many by the prior administration, and they're barred from entering the country. Families continue to be separated under cruel and illegal policies such as the Migrant Protection Protocol and Title 42, which has been used to bar people from entering the country using a public health justification, which was unjustified in the beginning and currently has become even more transparently baseless. These policies violate domestic and international refugee law. Today, we have a fabulous panel that will update you on our efforts to stop the dismantling of the U.S. asylum system, to maintain a system that is fair and humane and that welcomes those who are fleeing danger. We also have a terrific group of people who are going to talk to you about what we're doing here in the interior of the country to ensure that those individuals who are seeking asylum have a fair and meaningful day in court, that they are able to tell their story as to why they are entitled to asylum. We know that the United States has been a refuge for many individuals, families, and cultures for centuries. Unfortunately, it seems that we're getting further and further away from that freedom, from that liberty, from that welcoming the stranger. Now more than ever, we are at a crossroads in our country, in our world, to ensure that individuals who are in need of protection have access to that protection that is so, so critical. We are fortunate to have our legal teams, our pro bono attorneys, our community partners, and our clients who are able to speak out and who are fighting now more than ever for that reality to ensure that refugees are able to access our laws. We hope you will join us on June 15th at our annual Human Rights Awards, where we will celebrate those individuals who have been leading in this effort, or on June 16th on a virtual event that will also continue to this celebration. So without further ado, I pass this on to Ellen Miller, NIJC's Pro Bono Manager. Thank you so much for joining us. And thank you, Ellen.
Of course. Thank you, Mary Meg. We have a really exciting lineup, as Mary Meg said today, despite all of the challenges that we're facing. Just to walk through what we're going to be talking about today. So when we're talking about asylum at the border, Azadeh Irfani and Colleen Kilbride will be talking to us about what's happening at the border. Azadeh will continue to talk about what's happening in asylum within the regulations and the rules that are running the system. And then we have a wonderful team that will talk about asylum in the courts. So Rachel Milos, an NIJC attorney, Javaria Neagle, Matt Wexley, and Amarto Bhattacharya of Kirkland and Ellis. I'm sorry, Javaria and Matt are from United, and Amarto is from Kirkland and Ellis. They will be joining us to talk about what's going on in the courts. Like usual, we're going to end with some calls to action for how you can get involved and what you can do, and then leave a good amount of time for questions and answers. For those of you that have not joined us before, there is a chat function, and you can please enter your comments, your questions in the chat, and we have NIJC staff on board that are monitoring those, and we hope to engage you throughout the presentation, and then also line up some really great questions for the end. This is being recorded, and we will share the presentation in a follow-up email, as well as with the links to all of the materials that we'll be going through today. Due to the format, everybody is on mute right now, and chat is the way to communicate with us. So I think I've covered the basics. Let me know if I've forgotten something in the chat, and we're going to keep moving here. Let's see here. Okay. For those of you that have not joined us before, or for those of you that need a refresher, I'm just going to go through quickly who we are, what we do, why we do it. So the National Immigrant Justice Center, known as NIJC, is a partner or program of the Heartland Alliance. Our mission is to ensure access to justice for immigrants, refugees, and asylum seekers in the U.S. We have a staff of about 150 right now that span 5 offices across the United States. And we work with an integral service model that combines national and local advocacy and education with federal impact litigation and direct legal services. On a yearly basis, we are able to serve almost 10,000 non-citizens, and this is because of our great staff and a network of over 2,000 pro bono volunteers. So there's a lot going on, and I'm very, very proud to be part of this organization that has such a model that can combine the stories of clients, the experiences of attorneys, and lift up justice to ensure that our system is fair. Now, to keep us moving and to make sure that you're really paying attention, we're going to try something new here. And so what I would like you to do is go to this link or hold up your device to the QR code. It'll take you to a site, Mentimeter, and we're going to generate a word cloud. I would love to hear in one word what you think of the U.S. asylum system. Okay, actually, you can enter 3 different words, but you have to enter them 3 different times. But in one word, describe the U.S. asylum system. I'm going to then generate here the screen. Let's see if I can do this. Oh, just one second here. Let me see. Sorry, this is a new tool for us today.
Ellen, I dropped the link in the chat if everyone can access it there.
Thank you. Okay. And so what are we seeing here? We are seeing racist, broken, unfair, complicated, chaotic, traumatizing, misunderstood, cruel, flawed. I love this. Great. Perverse, discriminatory. Okay, so this word cloud is open, and you can continue to populate it through the presentation. But for now, I'm going to go back to the PowerPoint, and I'm going to turn it back to our presenting team. Excuse me as I maneuver this. I'm going to turn it back to our presenting team, and Colleen, you're going to take it away. Thank you.
Thanks, Ellen. Hi, everyone. While headquartered in Chicago, NIJC also represents clients at the U.S.-Mexico border. Remain in Mexico is a Trump administration policy designed to limit asylum that's been around since January 2019. The premise is that if you want to request asylum, you have to live in Mexico during the entire process and appear at a tent court along the U.S.-Mexico border. This is a photo of asylum seekers from Central America living in makeshift camps in a Mexican border city during COVID, waiting for their U.S. court hearing. Remain in Mexico was put on pause in March 2020 due to COVID. The Biden administration ended Remain in Mexico in January 2021. A lawsuit ensued, resulting in a federal judge in Texas requiring the government to restart Remain in Mexico, often called NPP by the acronym. So this new version, coined as NPP 2.0, has been back up and running since December 2021. Next slide. Great. Here's a photo of the tent courtroom in Laredo, Texas. It's at the foot of an international bridge. You can see the Rio Grande in Mexico in the background. Court hearings are held inside these storage containers and trailer type structures. People who are forced into Remain in Mexico face many challenges. Access to counsel is hard enough when you're stateside, so being placed into Remain in Mexico is a near impossible situation. Reports consistently show that only between 1% and 5% of people in Remain in Mexico have attorneys. And as an attorney, it's hard to represent people living across an international border in a town too dangerous to visit, so the ability to prepare is severely compromised. Sometimes clients are in hiding, children are often present, and there's limited access to cell phones in a lot of situations. Another major issue is the violence from Mexican cartels who regularly kidnap migrants for ransom. Some of our female clients have even been raped. Our clients have been kidnapped on their way to court. Sometimes they're handed over by Mexican police to the cartels directly. And cartels target Remain in Mexico individuals when they're at bus stations or they're waiting on an international bridge. In short, Remain in Mexico feeds criminal networks. And in the past, clients have slept overnight on the international bridge for the morning court hearings because of how early they're expected to be there. So they show up exhausted for their hearing. And of course, some people give up altogether because of such a hopeless and desperate situation waiting in Mexico. I'll just close by saying this current version of Remain in Mexico, called NPP 2.0, was supposed to expand access to lawyers and these fear of persecution interviews. We found neither to be true. The Remain in Mexico program itself is flawed, and there's no way to humanely do NPP in a way that honors the due process obligations we owe to asylum seekers. Thanks.
Thank you so much, Colleen. I'm going to jump in here and actually pivot to another egregious due process violation, which is the use of Title 42 expulsions under the Trump administration. It started in March 2020 and continued under Biden, and is still in force today, has resulted in about 2 million people getting expelled by Border Patrol, with a disproportionate impact on migrants of color. The particular reason why this policy has been initiated, it was purportedly under the guise of shielding the U.S. from COVID-19, so public health related policy that really was debunked very early on by public health experts who denounced it as a policy that really had no justification in science, and really was based in a very racist and xenophobic trope that basically equates migration and asylum seekers with contagion instead of allowing them to exercise their right to seek protection at the border. So it really was long overdue for this administration to end this policy. As you can see in the chart at the bottom, the Biden administration expelled more people than the Trump administration. The record numbers are really horrific and have led to over 10,000 people, 10,000 documented cases. So you can imagine how many more there are, but documented cases of rapes and violence and assault and even murders because of Title 42. So in many ways, the harms that Colleen described stemming from MPP, where the border became this bottleneck because the right to asylum was not not accessible anymore. The same thing is happening with Title 42 while the two policies are working in tandem. So it has created an incredibly dangerous situation for people who are simply trying to exercise their right. So April 1st, 2022, the CDC finally announced what we had been calling for over 2 years, which is the end of Title 42. And they announced that they would basically wind down the policy by May 23rd. Pretty quickly after that, there were 2 lawsuits filed. And those lawsuits were stemming from states that had a record of anti-immigrant policies. And one of those lawsuits secured a temporary restraining order to basically halt some of the preparations that the administration was rolling out. And we anticipate that it's possible that there would be a preliminary injunction as well. So there's a battle basically happening in the courts with respect to the future of Title 42, and in particular, the future of the rescission that this administration has announced. But at the same time, there's a battle happening in Congress where a lot of, a growing number of members of Congress have been basically raising alarm that ending Title 42 is premature here. And they are calling for the administration to have a better plan for managing the number of people who would enter once the policy is rescinded. Now, there's a couple of different problems with that rationale. One is that obviously it lays bare once again that it's not about public health, right? Mass mandates are dropping like flies around the country. There's fewer and fewer restrictions related to this pandemic. So, and as we, as pointed out before, public health experts denounced this policy back in 2020, and they are still denouncing it today. So, it didn't make sense back then. Why would it make sense now to continue it? And how is it that this, this policy is now morphing into a border management policy that should be that should make people pause in the first place, because that was never supposed to be the rationale for it. The other issue that I will point out is that Asylum was created very shortly after World War II, which was the biggest crisis in some ways that the world had seen. And it was in response to that crisis where, different nations had significantly, had returned thousands of people. In the U.S., for example, a boat of nearly 1,000 people who were Jewish was turned away under World War II. Under the same types of excuses that we see today. We don't have room. There are too many of you, or using vilification in terms of racial bias and xenophobia. So those excuses were used back then in order to say it's inconvenient. We don't want to allow this many people to enter the country, and they are in many ways being used today. But a community of basically a majority of nations have come together and ratified treaties that said we are not going to jeopardize the right to seek protection on the basis of convenience or on the basis of, let's pause it, maybe we'll resume it later. That's just not how it works. It's absolutely premised on how on the type of life or death questions and the persecution and torture that people are facing when they are making the decision to seek protection in another nation. So in many ways, this is a very misguided way that these members of Congress are proceeding. It is violating decades of protection under international and domestic law. And we would truly we would truly urge you at this moment in time in particular to call up your members of Congress, to email them. We have created an action alert to help make this easier for you, in order to tell them what you stand for, which is that the right to asylum cannot be compromised, and Title 42 must end now. So we're going to share this with you, especially at the end, and also drop it in the chat for you to take action. In the next slide, I do want to point out the way in which these two policies, these two anti-asylum border policies, often work in tandem. So with the story of one little girl in particular, we're going to call her Lena. She is an NIJC client, and Lena is a 10-year-old girl who has a cognitive disability. And when she and her mom and her sibling tried to approach the U.S. border to seek asylum, they were met with the first version of MPP, or Remain in Mexico, the policy that Colleen just discussed. And like many others, like tens of thousands of others, they were returned under that policy to Mexico. They tried to approach the border again under the Biden administration in order to seek protection once again. And when they crossed into the U.S. border, out of sheer exhaustion, after her mom and her sibling, Lena's mom and her sibling, fell behind, Lena did not realize that they were behind her, and she basically continued on. And she was apprehended by Border Protection by herself and designated as an unaccompanied child. Now, meanwhile, further behind, Lena's mom and her sibling catch up to Border Protection, and they frantically ask to be reunited with Lena, right? Instead of reuniting this family, what happens is that U.S. border officials use Title 42 and expel the mom and sibling back to Mexico. It takes almost a year and tremendous advocacy from NIJC attorneys for Lena to be reunited with her mom in the United States and her sibling. You can imagine that this is the type of tragedy that really would have been preventable had these two different kinds of policies not been in effect, and had the border not been closed basically to asylum seekers altogether. So ending these policies really is part and parcel of protecting the right to asylum and keeping families together. Now, I'd like to pivot us over to discussing regulations. I know it may seem sort of as a more in the weeds conversation to have here, but why regulations matter is that so much of the change that actually impacts the lives of migrants and asylum seekers on a day-to-day basis happens through the vehicle of regulations. So in particular, a very simple example of that is that there is a form of protection, which some may call complementary protection. So it's basically called temporary protected status, and permits people who are from countries that are facing civil wars, earthquakes, other forms of unrest, to basically be shielded from deportation on a temporary basis. And this happens through the unilateral decision of the DHS secretary. So in this case, it would be Secretary Mayorkas. And that designation is then codified into the Federal Register in the form of regulations. So regulations can have basically the power of shielding tens or hundreds of thousands of people from facing the risk of being separated from their families, of being abruptly sent back to a nation that cannot receive them. So a really powerful tool. And the prior administration knew that, right? So they suspended most of the TPS protections. They also issued a flurry of anti-asylum regulations and tried to basically overhaul the system through regulations alone. So even though they couldn't change the law because it hasn't changed since roughly 1996, they tried to change everything through regulations. So we've been urging the Biden administration to not just rescind the bad regulations from the Trump from their predecessor, but also to do better, to use these regulations as a vehicle for change. And their response has been, unfortunately, something that is also very concerning, which is that they are proposing a form of a new set of rules that would make people go through expedited removal and place them on a very, very fast track to have their hearings or have their claims heard. And to illustrate that, I'd like to show you a very quick flow chart that our policy director, Heidi Altman, actually created to show you a little bit of how chaotic this situation is. So it's supposed to streamline the process. It's supposed to make it easier for people to prevail in a non-adversarial setting. But there are a series of problems with that. So very quickly, if my name is Anna and I'm coming to the border to seek protection, I have to go through, under the expedited removal process, I have to go through what's called a credible fear interview. And that interview, if I pass it, becomes basically my asylum application under the new system of rules that they have created, and automatically creates a chain of different deadlines that I have to meet. So the first deadline is that I have to be interviewed within 21 days of that positive credible fear interview, within 21 to 45 days. And the asylum officer has to issue a decision within 60 days. I don't have time to find an attorney. It doesn't matter, you know. I still have to submit all of my evidence in a process that is infamously incredibly complicated. I have to submit my evidence, correct any errors that were in the credible fear interview within 7 to 14 days. Before my interview. So it's an incredibly fast turnaround. If you can imagine, I may only have 1 or 2 weeks to find an attorney, let alone provide an opportunity for that attorney to prepare my case. If I go through the asylum interview before USCIS in this non-adversarial setting, it may very well be the case that because I was so unprepared and so rushed, I don't pass, and I have to go in front of a judge. And when I go in front of the judge, it doesn't slow down either. I have to very quickly have my first hearing within 1 month, and then have an incredibly complicated hearing, which is called a status conference. It's the blue bubble at the top. And that status conference is a place where I have to say how many witnesses I have to call, what kind of claim am I going to make, are there any issues that I'd like to narrow. It's basically the kind of hearing that no one should have to go through without a fully prepared and competent attorney. But the problem is, I probably won't have time to secure an attorney there either, because that attorney will have to not only be secured in advance, but be secured far in advance that they would be able to review the record in front of USCIS, correct any of these mistakes, and be fully prepared within 30 to 35 days of that very first immigration court hearing. And after that, I have to face the merits decision, or the merits hearing, which is basically the trial in immigration court. And there again, it goes incredibly fast. And the rule makes clear that obtaining continuances is basically frowned upon, and something that the rules won't allow unless there is, a court closure or you know, the adverse party, the DHS attorney is unavailable, or those kinds of things. So nothing that actually has to do with me as an asylum seeker trying to prepare for my case can actually slow this down. So we're deeply concerned by the chaos that you're seeing in your screen, by the complicated system that is depicted here. And I really painted the tip of the iceberg. There are so many other ways in which there are intricate rules that are layered upon these timelines. So we're, you know, calling for the administration to really dramatically revise this proposed rule, and are even contemplating litigation, because we are deeply alarmed that so many people like Anna would basically be rushed to their deportation under an administration that is trying to protect the right to asylum. So keep an eye out for the comment that we'll be sharing. We'll be also sharing out a version of this flowchart for people to spend a little bit more time with alongside our comment. And if you're an attorney and are interested in this issue, we hope that you take a moment and also look at the comment and engage with the regulatory process, because, you know, it really matters to hear back about how difficult this process will be for lay people trying to navigate this, and for represented people if they're lucky enough to secure representation. So with that, I'm actually going to switch us over to asylum in the courts to my colleague, Rachel.
Thank you, Azadeh. Ellen, you can go ahead and advance to the next slide, please. So, you know, we've heard a lot about the challenges that our asylum seekers face, but I think I wanted to focus on a handful of the positive things that are happening in the courts, at least in the Chicago Immigration Court, that we have seen in recent months. So for starters, you know, during the pandemic, the courts were essentially shut down for the most part. No master calendar hearings, which are short status hearings, were able to go forward. And really the judges were operating on a very limited basis and only hearing a handful of merits hearings, which are the individual hearings on clients' claims. And that was to, you know, protect everyone's health and safety and to limit the number of individuals in the courthouse. That ended up resulting in just huge backlogs in the court. So a lot of our clients, you know, saw their cases kicked out into the future with no future hearing dates, or, you know, they got set for future hearing dates out in 2023 or 2024. And these wait times are extremely frustrating for our clients, especially clients with family members back in home country who are hoping to reunite with those family members at some point. So I think, you know, that was extremely difficult for us over the last couple of years. It was also difficult for our attorneys and our pro bono attorneys that we work with, because again, the uncertainty of timelines and when these cases were going to move forward was extremely challenging. Luckily, just in April, the court did tell us they're back to a full rotation. So things are starting to move again. We are seeing, you know, merits hearings going forward for our clients. We are seeing the court starting up with some master calendar hearings again. And so definitely, I think that everyone is happy that things are moving in the right direction again, and our clients are having an opportunity to have their claims heard. A second sort of positive development for, I think, everyone is that the court is finally modernizing and moving away from paper records. So for years, if you wanted to file anything on behalf of your client with the immigration court, you had to either walk to the court with a paper copy of your filing, or you had to mail it to the court. And you had to serve a copy on opposing counsel as well. Starting in February of 2022, the court said that all records are going to be electronic, starting from that point forward. So basically, if your client's case was filed after February of 2022, they're going to have an electronic record. What that means is that you can do all of your filing electronically. You can request documents, and those documents will be emailed to you. So it just really cuts down on a lot of hassle, and they're moving to try to make even old paper records. They're trying to make those electronic as well. So we're hoping that continues and continues to make things easier for us and for our clients. A third, you know, positive development I would say is that under the former administration, The former Attorney General issued a couple of really negative decisions that sort of undermine the ability of asylum seekers to seek protection based on domestic violence and gang-based claims. I think, you know, at NIJC, a big portion of our asylum seekers are from Central America and Mexico, and a lot of their claims are premised on domestic violence and gang violence types of claims. So I think it was really, really devastating for a lot of our clients in these types of cases. Under the new administration and the new Attorney General went ahead and vacated a couple of those former decisions. And basically just sort of reinforced the idea that asylum seekers do have viable claims that are based on domestic violence and gang violence and family-based claims as well. So we've seen a lot of success in recent months in terms of our clients presenting those types of claims. And then finally, one last sort of really positive change is that a new memo just came out in April from the Office of the Principal Legal Advisor, or OPLA, which is the ICE attorneys or the opposing counsel in our asylum hearings, and basically was encouraging prosecutors to exercise their discretion to sort of work with clients in terms of, you know, what other forms of relief might be available to them. So, for example, if client, you know, might be eligible for another form of relief, potentially dismissing their case or agreeing to a continuance in their case. In other opportunities, it would be something like after they've reviewed the client's file and, you know, have looked at the evidence that has been mounted on behalf of client, and even stipulating that they agree that the client has suffered past persecution, or that the client, you know, has proven that the government is unable and unwilling to protect them. Again, this is something that's really positive for our clients because testifying in an asylum hearing and an asylum case is extremely difficult and re-traumatizing for clients. And so if they wouldn't have to testify about certain material and bring all that up again, we see that as a really positive development and change for our clients. I think we've seen prosecutors exercising this discretion recently, and I think that leads us right into the next team of awesome pro bono attorneys that are going to be speaking with you, Matt, Javeria, and Amarto from United and Kirkland & Ellis, who recently worked within a client and with opposing counsel to get relief for their client. So I will turn it over to them.
Thanks, Rachel. My name is Amarto Bhattacharya. I'm an attorney in the litigation group at Kirkland & Ellis in Chicago. Would love to talk about the case that we recently worked on with Javeria and Matt and NIJC. I'll state at the outset that we wanted to include the name of our client and photos and things like that for this presentation, but our client's family at home is still in danger. And so, you know, despite the positive result that we had in immigration court, we still need to keep her identity confidential. So a little background on our client. She's from a Central American country where she lived with her partner and her 3 children. While there, she experienced very severe domestic violence, including sexual violence, physical abuse, emotional abuse. And additionally, without her knowledge, her partner was part of an organized criminal group of assassins known as sicarios that committed assassinations of very high-profile figures. Eventually, her partner got into his own legal trouble and agreed to be a government informant and testify against the assassins. But it became public that he had turned against the assassins. So our client and her family were forced to live in hiding under police protection. So at that point, our client was literally in an impossible position. Staying at home meant that she would be living in hiding with a partner who was abusing her. But leaving police protection meant that she would be at risk of revenge from the assassin group. So in 2007, she took her youngest son, who was still an infant at the time, and fled to the United States. She didn't have the money or the means to bring her 2 elder daughters, so she had to leave them behind to stay in hiding with family members there. She traveled to the United States. She turned herself in at the border. And while at the border, she faced several difficulties there as well that could have doomed her case for asylum, such as being asked to sign statements that she never would have agreed to had she been given enough time to read them. Even after she was in the US, the threats in her home country continued. Her partner was murdered by the assassins. The assassins were seen lurking near her family members' homes. And so all of these facts were the basis for the asylum case that our team put together, which Javeria can speak a little bit more about. Thank you.
Thanks so much, Marto. That was a really, really great overcap, a high-level overview of a very complicated case. So I just wanted to spend a few minutes talking about developing our client's story and in particular her credibility. So we got our client's case in 2019, which was a blessing because her trial date wasn't until the beginning of April of this year. So we essentially had 3 years to meet with her, to interview her, to develop her case, to develop her story. And, one of the, I think, unintended effects of, taking on a case during a pandemic is, pre-pandemic, we would have ordinarily met with our pro bono clients in person. And that, meant that while we would meet with them for longer stretches of time, we wouldn't meet with them as often. And what, the pandemic did for us, which was actually tremendous, is it gave us an opportunity to meet with our client more often via phone, albeit for shorter, spurts of time, but we spoke to our client at least a few times a month and were able to slowly develop, trust with her, but slowly also draw out her story. And so what I want to focus on is developing essentially your client's affidavit, her story. And an affidavit is essentially, all of the things that your client went through, her past persecution, why she thinks that she might face, future persecution. And it's the piece of paper or the many pieces of paper in our case that will support why your client needs to get a grant of asylum. But the important thing about telling your client's story is making sure that you tell it in her own voice. So in our particular case, it's important for our client to be able to speak in her own voice, both because she's going to be doing that at the day of trial. She'll be telling her story in her own words. But I think even more importantly than that, if she's able to tell her story in her own voice, that lends much more credibility to your client. And credibility is key in these asylum cases because oftentimes you won't have extraneous evidence to support asylum. All you'll have is your client's story. And so making sure that you put it in her words in a believable format will ultimately serve, to benefit your client. 2 other things, or I should say 3 other things that we did to bolster our client's credibility, although it's not required in asylum cases, but we had the time to do it, so we did. So number 1, in interviewing our client, we were able to figure out nuggets, of like who within her network, for example, could provide key could bolster key portions of her story. So in the 3 years, we were able to discover that she still had individuals in her home country that would be willing to provide letters of support. And so that's what we did. We drafted 1 or 2 pages worth of facts that were very important to her story. And we had witnesses essentially attest to those facts. And again, those letters of support, go to bolstering your client's credibility. Number 2, early on, we put our client in touch with a therapist, both because, as Amarto said, she experienced extreme trauma and, had the need to speak to someone. But, on top of that, we were also able to get a letter of support from the therapist. And what that letter of support did was ultimately show to the court that our client was a victim of past persecution. And number 3, we got a country conditions expert to do just that, to talk about the country conditions and the various threats that our client would face if she were to return to our home country. Again, not necessary, but the more you pile on, the more people you have validating key aspects of your client's case, you essentially increase your chances of getting asylum. Thank you. I will turn it over to my colleague, Matt.
Well, hi, everybody. My name is Matt Wexley. And by the way, Javeria didn't mention that she's the head of litigation at United. I'm actually a transactional attorney for United. So this sort of work is really outside my comfort zone. And I will say, first of all, that, and you've heard, it really takes a village and a cross-functional team to develop an asylum case. And working on an asylum case has really showed me how difficult and challenging it would be for an applicant without the support of lawyers and other subject matter experts to obtain asylum, no matter how deserving the applicant might be of asylum. And we had a great team for our case. We had 2 wonderful paralegals who are also translators who were passionate and dedicated, and importantly, were knowledgeable about the asylum process. We simply could not have obtained asylum without them. They connected with our client and she trusted them. And we used those paralegals to communicate with our client for scheduling and reviewing draft documents, obtaining signed copies of filings and letters of support from our client and from her family, from our client, and also from her friends and family in her home country. And as Javeria noted, we did retain an expert who specialized in Central American gangs, who provided a report that we submitted with our filing and was all ready to testify at the hearing about violence against women and the risks that our client would have faced as a single woman without family support, targeted by gangs, and the risks that she would have faced if the United States did not grant her asylum and she had to go back to her home country. And then also, as Javeria noted, we made a decision not to hire a psychologist to provide a DSM diagnosis. A lot of asylum cases, lawyers and the team will retain a psychologist. We made the decision that we didn't need one in this case, but as Javeria noted, we did provide a letter of support from our client's domestic violence counselor. And I'll just sum it up. My plug to all of you is to get involved, because there are so many deserving people that need our help. And personally, I've done 2 of these asylum cases, and while it's a lot of work and a lot of stress because you literally have lives in your hands, it's the best thing I've ever done in my 26 years as a lawyer. And I'm very proud of my involvement in this, and I would encourage all of you to get involved. Thank you.
Wonderful. Thank you to all of our presenters. We are now ending, we're getting close to the full hour here. And as you heard, there is so much going on at our borders and with advocacy for the regulations and the rules. But then also from this pro bono team, you hear that the amount of work and expertise that goes into fighting one of these cases. So as Azadeh said, this is a very, very difficult system, unfair system for those that are seeking protection, seeking security and dignity in our country. And for that reason, as Matt said, and we put in the chat, it does take a village, and that's why you're here today. We recognize that, we appreciate that, and we need you to help continue to lift up your voices. We have more information on our website. The links unfortunately don't work. You can't click on them in this PowerPoint, and so my colleagues are dropping them in the chat. We'll also send a follow-up email. We have an FAQ on Title 42, so you can continue to spread the word, inform your colleagues, your friends, those that you have conversations with that may want to know more, be open to learning more. We do have this call to action. So today we have a call to action for Welcome with Dignity is a call-in today to tell your members of Congress that we oppose the closing of the border and the lack of access to this asylum system and due process at the border. So we're also going to send you a link where you can tell your congressperson, your representative, that what you think about this process and why it's important to you that our system remains fair and these individuals have access to due process. There's more information on our website. Like I said, we're going to send you the information there. Mary Meg mentioned, if you're interested in continuing to help us celebrate with this wonderful pro bono team and all that we do for the immigrants and asylum seekers, despite the challenges of the system, June 15th and June 16th, you do not want to miss it. It's our Human Rights Awards. The 15th is in person. There's still a few tickets left, so join us in person downtown in Chicago. And if you can't, we'll see you on the 16th in the virtual presentation. If you are a lawyer, as Matt, Amarto, and Javeria said, we need you. The system needs you. The clients need you. You can do this. We have the expertise. You have the legal skills. We have 71 cases on our list right now. Please reach out. Please find the time. Our system needs you. For those of you that might not be attorneys, or maybe you are, we also need interpreters and translators. Our services, we serve over 108 different countries every year, individuals from 108 different countries. That's a lot of languages that we need to make sure people can have access to. In particular, right now, we're looking for Swahili from DRC, from Congo, Vietnamese, Wolof to English, and Amharic. If you or anybody you know speak these languages and might be able to volunteer some of your time and expertise, please also reach out. We'll send more links in the chat. And as always, if you are so inclined, we are a nonprofit organization and appreciate your financial support, and you can donate with the link there too. So I'm going to advance it. Lisa Coop, who is Director of Legal Services, is on to help manage our questions. But I just wanted to see here, I see in the questions that Mauro from the Pastoral Migratorio of the Archdiocese of Chicago said that they reached out after the last presentation and said that they were helping an asylum-seeking family along the border get in. NIJC was able to connect them, and that family is here. So snap your fingers, clap your hands. This is what our network can do when we all work together. Mauro, I'm so happy that that worked out, and I hope that this family is doing okay here in the United States. Lisa, are you on? Do you want to take this over for questions and answer?
Sure. Hey, everybody. Ellen, give me a thumbs up if you can hear me okay, just to check my audio. Yeah, I think we have cleared a lot of the questions that are in the chat, but we'll keep an eye on there. Ellen, are you wanting to take questions in another form, or we're mostly looking at what's already coming in?
Yeah, I think people can continue to ask their questions, right? And I know that there are some good ones that have already come in. Maybe we can review them for the larger audience.
Sure, we're seeing a number of questions about community members who are supporting Afghan evacuees and looking for ways to connect them with legal services. I did just drop into the chat the link to NIJC's legal services. We also partner very closely with the Muslim Women's Resource Center in Chicago. So if you are a regular participant in Java and Justice, you would have met them at our last event, and they have just really stepped up and become the hub for Afghans in need of services. So that's a great place for people to start to enter into the process of seeking asylum. NIJC continues to do pro se asylum workshops with Afghan asylum seekers in order to help people move their cases forward and get that process going. I think one of the other interesting questions that came up in the chat is about employment authorization. And that's, you know, I think when we talk about recognizing the humanity and integrity of asylum seekers, things like having access to employment authorization are critical things that are easy to overlook as we're talking about bigger blockbuster issues like Title 42 and MPP, which deserve every amount of conversation they get. But it is critical that asylum seekers, while they're going through the process, have access to resources, are able to support themselves, and have things like access to employment authorization. So we were heartened this last week when U.S. Citizenship and Immigration Services lengthened the amount of time one can get an automatic extension to their employment authorization card, which is great, but getting that employment card in the first case is a phenomenal uphill battle, made slightly less onerous by some incredible litigation NIJC and other partners have succeeded in recent months. But things, you know, some of those smaller things that just recognize the humanity of asylum seekers and help them recover and sustain themselves as they're going through the process are incredibly critical.
Lisa, I also saw some just kind of basic questions that might be of interest to some of our audience members that are not attorneys, you know, like the difference between affirmative and defensive at the border, and how do people access these different systems, or can they just take a plane from the border to Chicago and request asylum there? You know, would you mind explaining how that works?
Sure. Well, and Azade's presentation and Heidi's chart kind of illustrate how some of those processes are merging right now under this potential new rule that's coming into force in the asylum seeker. Typically, historically, somebody who has already had contact with the Border Patrol or with ICE and has been placed in removal proceedings is seeking asylum defensively before the immigration courts. Somebody who maybe overstayed a visa or came into the United States undetected would file an asylum application affirmatively with USCIS. What's happening under the new rule is those processes are sort of merging insofar as people who are apprehended at the border and placed in what's known as the expedited removal process are then, in some instances, will be allowed to first apply for asylum in a more affirmative-like posture, so before the asylum office, in what is supposed to be a non-adversarial interview. And if there were untold resources in the system and good training of officers, this would probably be a pretty good thing, as Azadeh spelled out. We have some real concerns about, maybe there are some good intentions in the system, but in application, the timing and the lack of resources and the existing backlogs make us a little bit dubious about the rollout and implementation of that process.
I don't know if we want to answer one more question, and I know that Javaria from United wanted to come back on for a last word as well. Lisa, are you seeing anything in the questions here that we want to highlight?
Yeah, I mean, just this last comment, I think, is so on the nose that, immigration has become so political, and we're heading into the midterms. And, that's, I think, part of the reason why we're seeing this political pressure to leave Title 42 in place, because we've let ourselves become untethered from the human stories and the human rights obligations that we have to asylum seekers. And this has become so politicized. And I think when people are able to, divorce in their minds the human stories from the politics of it, it becomes easier to make this a political wedge as opposed to an issue about humanity and human rights and our obligations to each other. So I'm so grateful for Javaria and your team and the incredible work that you've done, where you've really stepped into the void and done that advocacy and brought humanity back to the system. So we're so grateful for your contributions and all of our pro bono partners who do this important work.
The one thing, and I'm so sorry, I meant to say it. So this is the best work I've ever done. I am a litigator by trade. I've been with United Airlines for the better part of my career. And what I just wanted to share with the audience is Matt and I and Amarcho are not asylum or immigration lawyers, right? And you don't have to be. And that's in large part because NIJC partners with you so closely. Like every question we had, we threw it Rachel's way. She responded within 24 hours with really helpful advice, getting into the weeds with us. And so for those of you that are out there that are thinking, I can't do it, I don't know anything about immigration, you don't have to. NIJC will help you along the way. And I promise you, it is the best thing that you will probably ever do in your career. So thank you, NIJC, for giving us the opportunity.
Mary Meg, do you want to say any last words before we sign off?
No, I just want to thank everybody. I mean, it's been a wonderful program, and I hope those who in the audience have found it to be really valuable. And, kudos to United Airlines and Kirkland and Ellis for your hard work and dedication, and to Lisa and Rachel and Azadeh and Colleen and Ellen. It's really great to see how we are really advancing and fighting to uphold our asylum and refugee laws in a world where it's so desperately needed to remember that individual, that mother, that child, that father, those families who are desperately seeking protection. We can provide that. Thank you.
Great. And so with that, we're going to sign off. We'll send you the links so you can contact your members of Congress, representatives, and take a case, sign up to be an interpreter, whatever way you can contribute. We thank you, and we'll see you next time. Bye-bye.